pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, and we can't tell you how nice it is to see people and to be here. I believe our last meeting in this room was March of last year, and we've been meeting remotely. I believe, John Nagel, are you out there remotely? John Nagel will be joining us by Zoom this evening, and we will be able to hear him. He will be able to hear us, but he will be the fifth member of the board participating in this evening's proceedings. Ian, can we verify that John is... John is not on yet. Oh, he's not on yet? Okay. Well, let's proceed, given the fact that everyone is here and not everyone wants to spend all evening here. So, first matter this evening, Appeal 3050, the applicant EIP Partnership, LLC, property located at 147 Conestoga Road, requests an extension of time for obtaining a permit under Section 280-114 of the Zoning Code for an additional 6 months to December 24th, 2021.
Good evening.
Hi, good evening. Please state your name for the record.
Colin Whalen. I'm a member of the partnership.
Okay, and we have an extension request
Yes, sir.
before us. If you could explain why you are requesting an extension.
So we had several delays due to COVID over the last year and a half, specifically for our sewer module, which was finally approved. We do have a grading permit in hand that was issued last week. We're just making some tweaks to the floor plan to then submit our building permit, and that's why we're requesting the extension.
Okay, so given the fact that you've got the grading permit,
It's proceeding.
hopefully unlikely.
It's proceeding. We just need a little more time.
Yeah, okay. So are there any questions from the board? No. Okay, I would move that we would grant the extension. Is there a second? Second. Any board discussion? Any discussion from the public? Hearing none, I'll call the vote. We've been doing it in roll call fashion while remote, and given the fact that one of us is still remote, we should probably do that as well. So, Mr. Weitzman?
Aye.
Mr. Lord?
Aye.
Mr. Delizia?
Aye.
Mr. Nagel, are you out there? Okay, not yet. And I will vote in favor as well, so the vote is 4-0. Good luck with the project.
Thank you, board.
Don't take it personally. We hope we don't see you again. Thank you.
Thanks again.
Great, thank you. All right, next matter is appeal number 3102. The applicant John and Bridget McDonald, property located at 245 Willow Avenue and zoned R5 residential. The applicant seeks relief from section 280-35(3) of the code to construct a porch that will encroach 8 feet into the front yard setback. Is the applicant ready to proceed?
Yes, sir.
Hi, good evening. If you could, Norm, if you could swear them in?
I will be talking. I won't be.
Okay. I do. This is John F. McDonald. Thank you.
Okay, good evening. I'm not slighting you, but you were not sworn, so I'm just going to speak. Okay, all right.
Yeah.
Great. Good evening, Mr. McDonald. What brings you before the board this evening?
Hello. My wife and I live at 245 Willow Avenue, and we're here seeking relief for the front yard setback. Shall I guess just go into the presentation? Is that?
Yeah, please, just
Okay.
tell us, you don't have to be overly formal, just tell us why you're here. If you've got exhibits, if you could
Okay.
place them on the table, there's a camera above the table
Gotcha.
that will put them up on the screen.
Wonderful.
Thank you.
Yeah, I think everything's on the computer here. So As Bridget said, yes, she's standing here for moral support. I've done this before, but for some reason, when it's my place, it's a little bit more stressful. So, we bought our house 20 years ago, and have raised 2 children in the Radnor School District, and love it here. It's a twin, and we recently were lucky enough to be able to buy the other half of the twin. So that was about 5 years ago, and we're able to start moving forward on construction, and one of the desires is to have our front door on the front of the house, because right now the doors to both the twins come in through the side. And so, so the request is for us to put a front door on the front of the house, and then because of grading, there's quite a distance between the finished floor and grade, there would need to be some steps and a landing. So we thought a front porch would be a little bit more appropriate than just steps, slammed up against the front of the house. Let me just try to say, I want to jump to the site plan just to clarify. Here we go. Let's rotate counterclockwise. Okay. So this site plan here represents the existing property now. Now, we have gone through the process of consolidating the 2 lots, so it is currently a single property now.
McDonald, I'm sorry, if I could interrupt you for just a second. Because the actual legal record of these proceedings are being taken by our court reporter, we need to identify some exhibits, because you're going to be referring to things that are on the screen, but it may not be clear for the record what it is that you're looking at. So for purposes of identification, we'll identify the applicant's application as Exhibit A1. There is a package of photographs from KSM Architects. It's five pages of photographs, which we'll identify as A2. There is another photograph from KSM Architects, which is an aerial picture of the neighborhood, which we will identify as A3. There are documents, deed documents, and a lot consolidation document, which we will collectively describe as identify as A4. There is a site plan prepared by KSM Architects that we will identify as A5. Thank you for. Yeah, I think is that the just narrative? Yeah, there's just a written page from KSM Architects, which is sort of the cover page for A2. So yeah, so sorry about the administrative inconvenience, but okay. Now please proceed, and when you're describing items that are on the screen, we'll try to also identify them by those exhibit designations.
Okay.
Thank you.
Okay, sure. I apologize. I didn't write down which number exhibits they were, but
Okay.
we can.
I'll help.
Yeah, thank you. So Exhibit 5, I did catch that, was the site plan. And so this illustrates the consolidated lot with the house in the middle. We have a porch on the back, 2 sheds in the back. But in the front yard, currently, we show a 24.7-foot front yard setback. And we are proposing a 16.7-foot front yard setback to accommodate a 8-foot wide front porch so that we have steps that lead up to the front door. The 2 side porches and side entries would be eliminated from the house. So we would have a single entry on the front of the house. Now, and also just from a zoning perspective, that is the only relief that we're seeking. It is an existing nonconformity because we're a couple inches into the front yard as it is, but impervious and everything else is conforming based upon the site plan.
Mr. McDonald, could I ask you a question there? Because there is a zoning chart that's reflected on A5, which indicates that the current setback is 24.7 feet, and the requirement is 25 feet.
That is correct.
So I believe you just testified that you're currently non-conforming with respect to that
Right.
dimension.
Right. So it's supposed to be 25 feet, and the building's actually
Oh,
24.7.
I'm sorry, okay, I got it backwards, okay, yeah, okay.
Yep.
So you're missing 5 inches, got it, thank you.
There we go.
Thank you,
Yep.
sorry about that.
No problem. Oh, and actually, just to be super clear, the civil engineer noted it as 0.7 inches. So it's not exactly 5 inches. It's a little bit different, but it's close enough. Okay. So that is the site plan as it's illustrated. You can see that it would be a simple front porch on the front of the house. So the aerial image that we have, which is from Google Earth, is simply meant to illustrate,
And that's Exhibit A3.
thank you, the existing properties on Willow Avenue. You can see as the zoning was overlaid on the imagery, pretty much every single house on the street is non-conforming. And I believe this was probably because the zoning was enacted after 1920, which is when the homes were built, and it was simply laid over the R5 district. And so it was close, but not exactly. And actually, several of the houses on our side of the street have built porches on the front of the house, extending much further into the setback than what is being requested. So that was just a visual to give a general understanding. Now, part of the application had requested for photographs of adjacent properties, and so that is, there's no page number here, my apologies.
Right,
But
yeah, these are the A2 photographs, Norma.
there we go, okay. So as it's shown on the screen, in the upper left-hand corner is our property, and you can see it's a good distance from the street. Immediately to the right is 249 Willow Avenue, and the front porch is approximately 14 feet from the setback line. The next house over is 251. That's also approximately 14 feet from the setback, and it continues down the street. 253 is about 19-foot setback. So there is significant non-conforming existing properties on the street. And then also on the opposite side of the street, there's 257, which is about 12 feet, 256, which is about 10 feet, and 262, which is about 10 feet. So subsequent to this was all on our street. I realized that the R5 zoning district encompassed more than just Willow Avenue, and so just one street over, which is Aberdeen Avenue, I grabbed this from Google Earth. This is not part of the exhibits that you have in front of you. So I do have copies that I could leave. or-
Yeah, if you could provide copies to the board, please, that would be
Absolutely.
appreciated. Make sure our solicitor gets one.
So, so the first image is of Aberdeen Avenue, and you can see here, that it's just obvious that these houses are significantly closer than 25 feet from the setback. Generally, the setback is just to the left of the sidewalk. The next image, let's see.
I think we got the sense
Thank
from
you.
the
Okay,
Willow
I'm sorry.
Avenue photographs,
There we
thank
go.
you.
Great. Okay, so we'll submit those. And so ultimately, that was it. It was just that the R5 was, I believe, the 25-foot setback was meant to keep properties from being too close to the street, when in fact, as you can see, our neighborhood is really enlivened by being closer to the street. And so having a front porch, frankly, Bridget and I will be grateful to be able to sit on the front porch and engage our neighbors on a daily basis, which we do anyway, but it's just, would just be an opportunity that we would hate to miss. So I think, yeah, in wrapping up, I think that the houses were most likely built prior to the zoning being applied, and so I know that a hardship is required for zoning relief, and it seems to me that the neighborhood was constructed prior to the zoning, and what is existing is probably more commensurate with what the intent of the zoning should be.
Have you discussed this project with your neighbors?
I have, yes. We have two immediate neighbors here tonight. Oh, and the other thing that I wanted to submit was an email from my other immediate neighbor. So I have three of the immediate neighbors to testify. This is an email that I'll submit for the record that simply, it's from Chris Hess, who is at 249 Willow. It says, please accept this letter from Jackie and Chris Hess, who reside at 249 Willow Avenue, adjacent to John and Bridget. We are in full support of the porch patio project. We think that it will improve our street for the better and would love to see it happen. Please approve their plans. Please free to call or email if you have any questions. And so I'll submit that for the record as well.
Sorry, thank you.
Okay.
Questions from members of the board?
Just two. Have you explored decreasing it, the width, from 8 to 6, something like that?
So-
And then secondarily, trying to think, Kevin, if this did not have a roof, would it be per zoning? Is there an existing patio there now? Is there any
I don't
existing
know.
patio in the front? So it would not, they would still need a variance?
I would have to take a look at how it's constructed in the elevation off of the ground to make
Okay.
that determination.
Okay, because obviously a roof is, you don't need a roof for a patio. But how about the first question in terms of, do you look at 6 feet versus 8 feet?
Right. So, yeah, so 6 feet, we did consider that just with the door opening and with the steps being so close to the door. The 8 feet gave somebody a little bit more space to back up for the door to be opened instead of being butted up against a porch rail. So that was the first consideration. So we thought 8 feet. Since we're asking for relief, we thought that might be more appropriate. I will say that the 8 feet is still not as close to the street as the other adjacent properties.
Sure, but
My-
they're
my
not at
understanding-
issue right now. It's your
Understood.
property.
Yep.
You have 2 paved driveways on each side, or one, so the one on the right is going to go away. Is there a reason why you chose that one versus
So
the left?
actually, only a portion of that would go away. So we would maintain both driveways to keep cars off the street because it is a fairly congested street. And so having the 2 driveways, with my children now one's driving, one's getting closer, is just going to afford more on-street parking for other people.
Okay. But the roof question, Kevin, if you happen to figure that one, can you figure it out or no?
The roof absolutely would require it.
Yeah.
But I would have to see how it's actually constructed and the elevation. So I need to see construction details to make that determination.
Okay.
Typically, just a set of steps and a landing would not be without a roof. But if this is extending across the entire front, I think it would.
Right. Well, yeah, that's what I'm guessing too. So saying if there was an existing slab there and you were just expanding the existing nonconformity, which I know real well, that would be different. But obviously, with putting a roof on it makes more of a structure and part of the house.
My understanding of any deck, it is considered construction as part of the building, regardless if a roof is there. or not.
Yes, there's a different, they interpret it a little bit differently, which is great, more lenient towards the homeowner than
I see.
I think than the code says it's, but, and you have no plans of enclosing this at all, ever?
Never.
Okay.
The intent is for it to be an open porch to be able to engage the neighbors.
And is there a particular reason why it's going off the side of the house?
Yes.
Okay, good,
So,
great.
Because the driveway on the right-hand side is still going to be active, it affords us the ability to walk up the steps out the back, on the back of the porch. So there'll be steps basically on each side, and we can put a gate across from the back of the porch, across the end of the driveway, so that our dog can access the porch. And
I'm good.
Any other board questions? John Nagel, are you with us yet? Okay. Thank you. Are there any other testimony you want to provide? We'll invite the public to.
We need is the pictures and the.
Oh, yeah, I'm sorry.
To put in the record.
Yeah, the email that you read into the record and the additional pictures, if you could bring those up, that would be great. We'll enter the remainder of those exhibits into the record.
Kevin, do we usually accept an email as?
Traditionally, this board has had a position that unsigned emails
Yeah.
are given the weight that they give them versus a signed email or signed letter, more like somebody was presenting. But
Yeah.
I think that that's at the purview of this board.
Well, note that it does have the address at the bottom, so that does help.
Yeah, my apologies. They were coming tonight. They have a newborn, and they had some issues, so they couldn't attend.
How do you want to?
Wasn't important enough?
How do you want to label these? We have an
So
email.
there are additional photographs. The additional photographs that were described in the testimony, we can go with A6. And the email, we can go with A7. Thanks. Okay, great. Is there any? Is there any comment? Thank you, Mr. and
Okay,
Mrs.
thank you
McDonald.
so much.
Any comment from members of the public on this application? Hi, good evening. Yep, please.
I do. All right, Mike Feely, F-E-E-L-E-Y. And I'm at 244 Willow, directly across the street. And I am looking so much forward to that property. John and Bridget took over the house that was next door that was just needed to be taken over, I'll just say that. And what they've been doing inside out is amazing. So I can't wait. I get a chance to, we walk dogs, we run, we do all that kind of stuff in North Wayne, and everybody has the coolest porch. It really, that's kind of one of the characteristics of North Wayne. And in particular, you might want to call it Little Chicago, some of the cool little porches we got, it's just great. People waving, enjoying each other's company, and they're not kidding. They're going to be out there. We're all going to be hanging out. It is definitely in line with the aesthetics of the neighborhood. And, I mean, even just the mail carrier, being able to go to one door and not try and figure out which one to head to is helpful. So I'm looking forward to it. So I'm all in, and I know so many folks are.
Thank you, Mr. Feely.
Thank you.
Anyone else?
Hey, guys.
Hi, good evening.
Sure. I do. My name is Michael Azzarano, A-Z-Z-A-R-A-N-O. Hi, guys. I'm a resident, 30-plus year resident of Radnor, 20-plus year resident on Willow, neighbor of John and Bridget. I live immediately next door to the left, looking at it as is. I just think it should be conveyed to you guys that they've been extremely transparent and open and discussing this with the neighborhood and the neighbors as we do on Willow. And I can say that everybody I've talked to is in full agreement that this project should go forward. So I'm just here to support them 100%.
Thank you, Mr. Azzarano.
Thank you.
Any other members of the public wish to speak on this application? Okay, seeing none, I would move that the board grant the,
We also had this one.
oh, I'm sorry.
So we will one more letter, if you want to read that out.
That's why, okay, that's why. We have one more email, I'm sorry. This is from, let's see, Marie Edwards. The address is 239 Willow, and the note indicates that she wants to confirm that she received the notice in the mail about the zoning application. She believes the rendering shared offers a significant improvement to the neighborhood and would vote to approve. She apologizes for not being able to be here, but the letter is expressing support as well. Thank you. A8, yeah, thanks. Okay, with that out of the way, I would move that the applicant be granted the requested relief based on the exhibits and testimony presented here this evening. Is there a second? Any board discussion? Okay, no board discussion. I'll call the vote. Mr. Weitzman? Aye. Mr. Lord? Aye. Mr. DeLisi? Aye. And I vote aye as well, so that's 4-0. Good luck on your project, and thanks for stopping in. Is the applicant for Appeal 3103 here? This would be Teresa Rainey. We're going to call that case now. Appeal number 3103. The applicant, Teresa Rainey, property located at 9 Devonwood Road and zoned R3 residential. The applicant seeks relief from Section 280-115.1B of the code to operate a yoga studio from her residence as a traffic home occupation. Is the applicant ready to proceed?
I do. Thank you. Teresa Rainey, Teresa, Rainey, Raney. Thank you.
Good evening, Ms. Rainey. Before we begin, I'm going to just identify some of the materials that you've provided in your application to the board.
Okay.
We're going to identify the application as Exhibit A1. The deed for the property we will identify as Exhibit A2. There is a copy of a site plan included with the application, but you provided also a separate site plan, which I think we're going to refer to as Exhibit A3. This is a site, an undated site plan showing the property at Devonwood Road. That will be A3. Bear with me for a second, sorry. And there are some photographs which, if they're loaded into the computer as well, they are perhaps a bit more legible. The photocopying wasn't great on the application, but there's a collection of 1, 2, 3, 4, 5, 7 pages of photographs that will identify as A4, but as we go through the testimony, we can identify them more specifically for the record. Thank you, Ms. Rainey, for indulging that administrative interruption. What brings you this evening? You're going to need to speak into the microphone. What brings you here this evening?
Hi, I'd like to have permission to use my home as, in the back end of my home as a yoga studio.
Okay. You are not represented by counsel, is that correct? No. We're going to kind of walk you through the process because this is not your garden variety request.
Yes.
And it's a little technical.
Okay.
So we're going to go through the sets of requirements that you're going to need to satisfy in order to make the claim for a special exception.
Okay.
This is a, we all right? Oh, okay, I'm sorry. Hold on for one second. I believe there's someone requesting party status on this proceeding. If you could come up and be sworn, and then we have some questions for that request, and then we'll see where we go from there. Norma, if you would swear in the...
Schaefer, I'm gonna spell it. Mari is M-A-R-I, middle initial A. Schaefer's S-C-H-A-E-F-E-R. I reside at 17 Devonwood Road.
Okay, Ms. Rainey, hold on for 1 second. We'll be with you in a second. We need to speak with Ms. Schaefer for
Should I
a
sit
few.
down?
I mean, at your, I mean, it might be more comfortable. This could take a couple minutes. So, Ms. Schaefer, I believe you said 17 Devonwood, so a relatively nearby neighbor.
Yes.
And why are you requesting party status this evening?
I'm contending that the applicant does not meet the burden for relief to operate the traffic home occupation under some sections.
Yeah, I'm sorry. You can-
Sorry about
yeah,
that.
Yeah, sorry.
I contend the applicant doesn't meet the burden for relief to operate a traffic home occupation under, I have some sections that I could note, and I have some handouts.
We'll get to that.
Okay.
You'll get your chance.
Okay, do you want me to cite the sections now or later?
No, not necessary. Not necessary. Any questions from the board as to whether Ms. Schaefer is entitled to status?
The only question I have is, sir, thank you. The only question I have, Ms. Schaefer, is, it looks like on the map, Devonwood is a U-shaped street. It starts and ends in a fashion on South Devon. Where are you on that?
I am just down the street on the same side as Ms. Rainey's property. I have a map I brought with me.
Going towards the curve in Devonwood?
Yes, going down towards Crestview.
And before you get to Crestview? You're located before you get to Crestview?
Yes, before I get to Crestview.
Okay, all right, thank
So-
you.
Okay, I
Further
see
questions?
no basis to object to Ms. Schaefer being granted party status. Okay, so we'll be back to you in a bit. Ms. Rainey, we're back to you. Thank you. Sorry. Air traffic control this evening. Okay, so tell us about your proposed use of the dwelling as and this is a traffic home, I forget the term. Traffic home occupation, thank you. Tell us what you're hoping to be able to do.
Okay, so I just want to run some small yoga classes, and the back of my house is really amenable to this. I have a rear entrance. I also have an other exit if necessary. I have a nice long driveway that actually goes all the way down and around the back of my house. Probably could put in 15 cars or more. The clientele, that I anticipate coming into the studio will all be very quiet. There's, I don't see how that could impact anybody. As far as that goes, it's yoga after all. I mean, and then that's really, they walk in, they take an hour class, and they leave.
What are the sizes of the classes?
Right now, they've been around 2 to 5 people. They're very small. I've had some, prior to this, and they've all been very small. If I have 5 people, that's a lot. So it's very small.
And it will only be you conducting the classes?
Yes.
You don't have anyone that you employ to
No.
conduct classes? And you indicate, if we could call up the site plan, are your exhibits on the,
So I do have a lot of pictures. I do have a site plan that shows the driveway and the back of the house and the entrance.
Use this to scroll through.
Oh,
This is
thank
everything
you.
that you submitted.
Oh, thank you.
and
Okay,
Norma,
I
this
didn't
is
realize
A3 that we should be looking at.
I didn't realize that I could do this, so I'm just scrolling through.
Mr. Chairman, maybe we have, under B4, it says you cannot serve more than one client or customer per hour. So if she's testifying that she's going to give 2 to 5, be conscious you just testified that, so.
I would like
I was going
to
to say, if this is quick, it's going to be quick.
I would like to add something to that.
Wait for the board to have
Yes,
the
sir.
discussion. I do understand that. She's
Yes.
requesting relief from that.
She is?
The way the notice reads is she's requesting relief from 281.15.1B.
Okay, my assumption was a special exception. So you're
Well,
looking for a
well,
variance then?
The problem is, this is not stated as a special exception application. She needs both.
Yes, that is,
need to-
well, you need a variance, no matter what,
We need
so.
the variance for
Okay.
certain of the things that we're going to be talking about. I'm sorry. Sorry, Norman.
It's good that you're clarifying what her relief will be, because I didn't get that. I thought it was just going to be a special exception until I heard more than two.
Yeah, no, in fact, you know, I would argue that
Well, put it this way, until she does,
the advertisement is, you have to know that there's another piece to the puzzle to find the notice sufficient.
well, I was just saying, until she testified that she was going to have more than one person, she didn't technically need at least on that issue, didn't need a variance. Now that she has, she needs a variance, no doubt about that, which means you need a hardship. So, but we'll go through. I just want to
Well,
point that out.
we also have an adverse party that I
Yes.
suspect is going to make some of these same arguments.
Yes, that's great. Well, getting it ahead of time.
I'm sorry. There are a bunch of lawyers on this board. I apologize for that.
No, that's okay. And I do have a question, if you don't
Yes.
mind. The way that's worded, does it say how many hours that pertains to? Is that per hour, per day? How many am I allowed per day? If
well,
that's just per
the
hour, that would make a difference.
The provisions are fairly clear. The zoning code is not a model of clarity in many respects, but it is rather clear on these issues because of the importance that the Board of Commissioners places on these sorts of activities in residential areas. So I'm not your lawyer. You can calculate how many people you can have participate in a class in a particular day, assuming that you would be able to obtain the relief that you're looking for. But let's just proceed with the testimony. I don't want to prejudge what is going to find its way into the
Okay.
record, but again, as I noted, this stuff is fairly technical, and you know, part of our expectation when applicants come before us is that the applicant fully understands both what the requirements are and where their application does not fit with those requirements.
Okay.
So the question as to how many and for how long, those are all answered in the zoning code. Okay? Please proceed.
Okay, so, well, do you have any questions? I can just say that my pictures show that I have a very large driveway that goes all the way, the side of the house, all the way around and wraps around to the back. It's all wooded, really private. There's a fence my neighbor has next to me on my right, and my neighbor on my left, which wouldn't impact anyway, also has a large fence.
Sorry, Norma, those are the photographs that are at A4. So what hours during the day do you expect to conduct classes?
I would probably just have one in the morning and one at night.
What time in the morning, what time at night?
9:30 in the morning, and usually around 7:30 at night.
And how long do the classes extend for?
1 hour.
And on what days of the week are you looking to conduct classes?
I would like to conduct the classes most days, Monday through Friday, but on the evenings, probably 3 nights a week, maybe a Saturday or a Sunday midday, if possible. But right now, I'm doing Tuesday, Wednesday, and Friday morning. So 3 mornings right now, and I'm doing Tuesday, Wednesday night, and Thursday. Tuesday, Wednesday, so 3.
Okay.
3 daytime, 3 nighttime. It's very small. 6
Oh,
a week right
okay.
now.
Do you know whether any of your immediate neighbors conduct traffic home occupations from their homes currently?
I don't believe they do.
What impact do you think that having these classes conducted will have on traffic in the area, parking in the area, and generally the residential nature of the neighborhood?
I think it is a good benefit to the neighborhood. I think that if people needed to park in my driveway, they're absolutely welcome to. There is enough room for at least 15 cars in my driveway. And also, I've had a few of my neighbors who actually like to attend the class and walk over. So they actually like having it. They're excited about it. And it's beneficial to everyone's health.
And one other question. So what prompted you to submit the application? Did someone from the township say, were you conducting classes and someone from the township said, excuse me, but you can't do that without a zoning?
I was contacted by the township.
Okay.
I had a studio in Newtown Square that I had to close during COVID. And so that was really devastating to me. So my children and my boyfriend made the back of my house into this.
Okay. Any other questions from members of the board?
Kevin, I assume you keep records of the traffic home occupations?
Yes.
Do you know if there's anything within 500?
Those that apply for them?
Yes, of course.
Yes. So we did a search, and nobody came up within the 500-foot radius.
Cool. Thank you.
Miss, I've got just a couple of questions. Presently, how many people do you have in an average class? How many students?
Right now?
Yes.
3.
3, on average.
Yeah,
So sometimes you have 2, sometimes you have 5?
yeah, and 5 is rare.
Now, are you able to calculate to what percentage of your house is taken up with the yoga studio? There's a couple of pictures of a yoga studio. I assume those pictures show the current state of the yoga studio on the inside of your house?
Right, it's the back end of my house, which has a separate doorway. And then there's also a big glass double door, for safety reasons, that's also a part of it. And the room itself is 18 by 25, so it's on the site plan. I'm not an architect, so I don't really know, the percentage of the size of the house.
You say it's on the site plan?
So this is difficult. I went many times to get this done. I had my son go into the city to have it blown up. They put it on large paper but didn't blow it up. At that point, I gave up because I think I tried 4
Well,
times.
The reason I'm bringing this up is because under the zoning ordinance, it says that it shall not utilize, that is, in other words, whatever you're doing there, in your case, it's yoga, cannot be more than 35% of the gross floor area or 400 square feet of the dwelling unit, whichever is less. Have you made those calculations?
I did not specifically, but I can tell you that it's just a family room, that the rest of my entire rest of my house, which is 2 stories, is the whole rest of the house, and that's just a family room.
But as you stand here tonight, I mean, you really can't tell us what the percentage is or the actual square footage that's devoted to the yoga studio.
I can't answer that question.
As part of the yoga class, is there music involved?
Very quiet music, yes. My job is to try to make people calm and breathe.
That's all the questions I have right now. Thanks.
Thank you.
Rich, anything?
I have a question for you. Are there any signs or displays outside of the house?
Just in my driveway, to let them know where it is, because they don't even come to the front. They would just go to the driveway, to the entrance, which is an enclosed deck, into a door that's separate from, my house.
Is that sign visible from the street?
I don't think so. No, I was told earlier that I'm not to have signs in the front, so I removed them.
don't have a question for the witness. I have more general
Yeah,
questions. I
we'll,
can hold that.
yeah, we'll get to that. Ms. Schaefer, any questions?
Okay.
This is your opportunity to ask questions of the applicant. If you don't have any, that's fine. You need to be over by the mic, sorry.
I'll just give my presentation to the board.
Okay, we'll get to that in just a second then, I'm sorry. If you have no questions for the applicant, we will, thank you. We'll get to that. If Ms. Rainey, if you don't have any more testimony on behalf of the application, you can probably be seated now. We're going to read a letter into the record, and we're going to ask for any other additional public comment, and then we will permit Ms. Schaefer to make her presentation. And then if you have questions for Ms. Schaefer, you're certainly entitled to ask questions
Okay.
of her. So if you could just hold on for a second, have a seat. First, are there any members of the public that would like to speak to this application? Hi, good evening.
I do. Kathleen, Kathleen, Wright, Wright.
Ms. Wright, good evening. Where do you reside?
I reside on Lenore Avenue, which is in the neighborhood but not directly impacted. My concern is of a zoning nature, though. R4 is Lenore Avenue. This is R3. And some years ago, when they wanted to put a child care home across the street from me, it was very difficult. We went through a lot with the zoning board at that time, and they upheld what was in the zoning code at that time, which we appreciated.
Okay, thank you. Any other comments from members of the public on this application?
Good evening. Yes, I do. John M. Schrems, 15 Devonwood, SCHREMS. Live at 15 Devonwood Road. I got the notice in the mail. I didn't even know about this. Haven't even noticed signs or anything like that you're talking about. And traffic in the area, if she's had any classes, no different. Traffic through the neighborhood's always been good. I think it's very beneficial that she do this. She did lose her business due to COVID, and I thought this was very aspiring for her to do that. And I do know that some of the people in their neighborhood take classes there, and I think it would be a good thing and not affect the neighborhood. There's, I'm 4 houses away. Don't even hear anything. When her kids used to live there, couldn't hear anything. So, but I fully support her.
Thank you, Mr. Schrems.
Thank you.
Appreciate it. Kevin, do you know if the mailing of the notice to the required residents was made?
I believe it was. There should be. The file is up by you. If I can come up and grab it, I can take a look at the posting. In fact, yes, Ms. Rainey dropped those off at the front counter when she dropped.
Okay, thanks. Brad has it. Okay. Any other public comment? I'm sorry.
You looked at me, so.
No. Well, there are people behind you. You're special. I'll call on you specific. Hi, good evening.
I do. Arnelia Hollinger. ARNELIA. Correct.
Hi, good evening. Please speak into the microphone.
Good evening. My name is Arnelia Hollinger. I live on Devonwood Road, South Devon Avenue, right at the corner of Devonwood and South Devon. And I haven't noticed anything different. What I wanted to know is, how does that affect property value? Will this change the zoning totally once this is approved?
I got to tell you, if I had that crystal ball handy, I wouldn't be sitting here. I'd use it for better purposes. But certainly, the effect on the neighborhood is one of the things that the board considers when we receive applications of this sort. And, you know, this application may or may not be approved. It depends on, you know, probably the next 15 minutes or so. But that certainly the impact on the neighborhood is one of the things that we consider when we consider these applications.
All right. Well, I'm in favor.
Hold on, but not the value. The impact on aesthetics, is it in the nature of the business, in the neighborhood, stuff like that. That's first. Your second question is, does this change the zoning code? No, it does not. This is only for this property, for this applicant. It even says in the code, if you change the use at the property, so if she wants to now do a gym, she has to come back in front of us. So it is only good for her, for that property location. And if anything, to a certain extent, it shields neighbors because you cannot have another home traffic occupation within 500 feet of another one. So it actually prevents anyone else from having businesses. But this is only unique to this property and to this applicant.
Thank you. That sounds good. Thank you.
Sure. Thank you. Anyone else?
Yeah, I do. Marcin Jasko, Marcin Jusko, and I'm at 12 Devonwood Road.
And I believe I have a letter from someone
You have
you know.
it, right? My wife. So if you can read it, then what I can just add it. I've been in it for 5 years. I have 3 beautiful kids. They go to Radnor School District, and I don't see any impact, and I'm right across Teresa. So the traffic was normal. Don't notice anything. So I'm for it, and I'm okay with it.
Thank you, Mr. Jusko. If there are no other public commenters, I have a letter from Anna Jusko of 12 Devonwood Road, which reads, I, Anna Jusko, the neighbor of Teresa Rainey, property located at 9 Devonwood Road, zoned R3 residential, who operates a yoga studio from her residence, would like to express my support of the yoga studio, and I attest I have no objection against the yoga studio. This property causes no stress, problems, or disturbances of the neighbors' everyday living. I live across the street, I've never noticed any disturbances, parking issues, traffic jams, unpleasant noises. All sessions occur smoothly and quietly. Ms. Rainey dedicates her time and effort to help others in the community, especially during these difficult times. Sincerely, Anna Jusko. Okay, so I think that's all of the public comment we have. Yes, that'll be, that letter will be A5, Norma, thank you. Ms. Schaefer?
I have handouts. Do I just pass them out?
Yes, you should make sure our solicitor gets a copy and Mr. DeLizia gets a copy. And if you have enough for everyone else, that's terrific also. Thank you.
Yeah, can I show this at the same, can I show my exhibits at the same time?
Yes,
Is there a possibility to do that?
Since they're not on the computer, if you can place them on the table, there is a camera directly above your head. Yeah, they got it. So Ian will take care of. And before we get into them, why don't we go ahead and identify them?
Okay, I have, different from the handout, I changed a little bit. This is, exhibit A would be a,
I'm sorry, we're going to call these C
okay,
exhibit.
C.
So we'll start with C for contestant.
Okay.
It's a long day, I'm running out of words. So
I like
C,
contextual.
C1 will be, I guess I'm sorry, go ahead.
This would be the Google map, just
map.
giving you an idea where Devonwood is if you weren't familiar with it and what the neighborhood does look like. So I didn't use the satellite version because there's a lot of trees there and it would obscure most everything, frankly. Do you want to see the next one, next exhibit?
Yes, go ahead. Yeah, let's go through them promptly.
This would be a post I pulled off Zillow, which would give an idea of the size of the family room in question.
Okay, and that's C2, Norma.
Is that the part that's highlighted, 26 by 50?
Yes. This is from the website of Namaste Yoga, showing the facility. And if you look at it, this is slightly different from the photo you have. I thought I was Xeroxing this one, but didn't. You can see there is a door to an exterior corridor in the photo on the table here.
And that's at the subject property?
This is from their website, yes.
So this is the subject property,
Yes.
so that'll be C3.
Is that the photograph of the interior?
John?
Yes, that is. It's slightly different. I grabbed the wrong one when I got them Xeroxed. Okay. This is a street-level view of Devonwood.
Hold on, I don't think we have that photograph.
I thought you did. Might be in there. They might be out of order. But I can leave it with you if you don't have it.
I can, why don't you trust me on this one? I
All
don't
right.
think it's in the package.
Okay, I'll leave it with you then. Okay.
Which is not to say that you can't introduce it supplementally.
Okay. This is the picture of the driveway in front of 9 Devonwood, and you can see the sign in that one picture. This is from the street.
And that'll be C4, Norma?
This is again from the website, one of the postings from August of 2020 that I'll be talking about.
It's at the back. It's at the back.
Yeah, sorry, guys, I didn't put them in quite order.
That'll be C5.
Again, another posting. This one is from October 21st of 2020 from their website.
C6. John, this one right here.
This is a Groupon that popped up when I was looking for a different Groupon showing the advertising that
I'm
for the
from
studio.
another century. Did you
it's
say
an-
Groupon?
It's a coupon app called Groupon. I was looking for a restaurant and it
Got it.
it
C7.
suggested I do this too. So
Okay, C7.
this again is from the website of the business,
Says
showing
our-
the number of.
It has our classes at the top. That'll be C8.
Again, this is from the Facebook page of the business, and the posting is December 30th of 2020. I'll be talking about this.
C9.
This is a picture of the sign that was visible also during the winter months.
C10.
This is a recent schedule that I just pulled for this week. It's from their
Schedule, John,
website. It's the
right here.
schedule of classes for this week.
C11.
The instructors that are listed on the website.
12. C12.
And this is the, also a page from the website, sort of the about part for the business.
C13.
That's the last exhibit I have.
Okay, great. Please proceed. Thank you.
Okay.
Sorry about the administrative stuff.
Thank you. Again, I am here because I contend the applicant does not meet the burden for relief to operate a traffic home occupation under the following sections. And I want to say up front, this is about zoning, not yoga. And for section 280.115.1A1, on the size, I say the applicant does not satisfy the requirement of using no more than 400 square feet of the dwelling for the business, The MLS listing has the room as a 26 by 17 family room, which would be 442 square feet. Ms. Rainey testified just a few minutes ago that the room was larger and would equal 450 square feet. With the corridor that's outside that, I'm going to contend that that would even be greater than that amount and might be closer to 500 feet. That's how the public enters that room, through an ancillary corridor there. Okay, so under section 280.115.1B4, class size of not more than one client or customer per hour. Hang on, I'm just going to move along with my exhibits. Here's the on class size. One second. From the inception of this plan, this was a move, by the way, from a strip shopping center in Newtown Square at Route 252 and Route 3. The business was there for about 4 years, from what I understand. And from the inception of the plan more than a year ago, this move was billed as a transfer of the location for this well-established fitness facility. And you can see on the posting from August 12th.
Mrs. Schaefer, if you could move the exhibit so they can't, yeah, it's kind of hard for you to, you have to look up and see how it's going, but yeah, so everyone can see that, because we're going to get that request.
The applicant states on this, I will continue to offer yoga in small groups, private and semi-private, as well as small group fitness and dance cardio classes. So this extends beyond yoga. The business has been marketing the classes on its website, Facebook page, and even Groupon, as I said. A Facebook page for a pop-up class on December 31st said that the studio could accommodate at least 10 students. Coincidentally, that pop-up class that fell within the time period where the state ordered all indoor dining, theaters, and fitness facilities to close in an attempt to contain the coronavirus surge. For parking, on section 280.115B, subsection 5, I guess it's called, I do not believe she meets the burden for off-street requirements for the parking and the buffer that's also in that section. Most houses on Devonwood Road, they're older. They were built in the 50s, the late 50s, I would say, maybe early 60s, and the driveways are short. You can get usually 2 cars in there, maybe 3. People do park extra cars on the street. It would be, anybody who has more usually parks them on the street, frankly. From what I've seen at the house at 9 Devonwood, they can fit like 3 cars in there unless they go around the side of the house and into the backyard. There has been some gravel recently put down on that, on both that part in the front. On the front of the side there, that would kind of give it that extra space, but really to get in and out of there, you would have to move cars. These cars would not be able to independently flow from the back of the house through the front. It doesn't allow for, the configuration doesn't allow for that. So you would need a rear
Norma,
area.
for the record, that's C4,
Yeah.
the photograph of C4.
Also, the gravel driveway and the lack of proper lighting along there would not meet requirements under Title III of the Federal American with Disability Act.
We don't
which-
have jurisdiction over that.
It
Let's
does
move
cover
on.
yoga studios, according to the Mid-Atlantic Regional spokesperson, and they said that it would be needed to be paved and graded. And if that's the case, the additional paving of the driveway area may run into some increased impervious surface issues. There's also a fence where the parking area is located, but no evergreen buffer as required under the statute, or the section. So, let me just hang on for a second. Any one of the three items that I've just referenced, the size of the room, the class size, and the parking, I think would be enough to deny the requested for relief. In addition, under section 280.115.1A, subsection 5, commercial signs, there have been signs identifying the location of the business displayed at the home since at least November 2020. Sometimes they've been in front, sometimes they're in their side, but they are visible from the street. For the non-resident employees, I have not seen any names on the schedule, I'll be honest with you, but the number of named instructors on the website does, they do not appear to be in an assistant capacity, and there could be potential for this location to be used as a shared workspace with other fitness instructors. And as you can see from the schedule under section 280.1151B, subsection 4, classes do extend past the hour of 8 p.m. Based on that criteria, I respectfully ask that you deny the petition for relief for a traffic home occupation. Are there
Thank
any
you, Ms. Schaefer.
questions?
Any board questions for Ms. Schaefer? Ms. Rainey, do you have any questions for Ms. Schaefer?
I actually want to go through all of this with her.
Mr. Chairman?
Because this is just her assumption of what is the situation.
Do we have the handheld mic? It may be beneficial to use the handheld mic and the other use the podium mic.
I would like to retort everything, because this is just her assumption. I've never even met this woman, never even seen her before, actually. And actually, everything that she's gone through is completely incorrect.
I would invite you to ask questions of Ms. Schaefer.
Okay, let's go one at a time. We'll start with the very first picture, which I believe you got off my website. Now, let me explain. I had a website made for my original studio that I put money into. So some of the pictures are from the old website because that's something I couldn't afford to change. And also that would be the same with Google, which is what they do. That was a location in Newtown Square, which I closed. But the pictures on Google, of which she has, are old. As a matter of fact, I was looking at one of them today. There's pictures of the cars. I don't even know any of those cars. I don't know who those are. The pictures of the studio, if we could go through one at a time, and I would like to do that, are not accurate as to what she has to say from Google, number one. Also, with regard to the instructors, I do teach all the classes. I didn't have the money to have my website changed to remove the teachers that I had. I kept the website up just for convenience for the people that came.
Okay, why don't we, I think it might be beneficial if we kind of focus the discussion a little bit.
Yeah, but I need to go through one individually each because of all the damage she has
let me ask three questions.
Yes.
And then we'll see where we go from there. With respect to the contention and the testimony that's in the record, to the extent that you will have group classes, is that accurate?
Very small group classes, that's accurate.
And group for this purpose means more than one?
Yes.
Okay, thank you. With respect to the schedule that it was described, the zoning requirements are that the traffic home occupation be conducted during specified time periods and on specified days. The contention is that classes will be conducted outside the permitted periods. Is that correct?
No, I would be willing to change whatever hours were necessary to comply. I believe if I have one class, it's a restorative yoga class that goes into 8:30 p.m. I would be willing to change that to 7 p.m., not a problem. So it would go 7 to 8. I have no problem with that.
Okay. And with respect to the issue of parking, there are specific parking requirements that are in the zoning code for when you have a traffic home occupation. And the contention is that you do not have sufficient space to have the required amount of parking, which, by the way, is additional to the required amount of off-street parking that a dwelling unit is required to have in R3, which is 2 spaces. So at a minimum, you would need 4 spaces.
Not a problem. My driveway, this woman doesn't live in my home, I do actually. I know the size of my driveway, which is the whole way, the front, all the way along the side, winds around all the way to the back, which is on the site plan. If you would like me to do that, I can pull my car all the way around to the side, and then my students would be willing to park, the 4 of them that there are, can park there all at the same time, and then leave at the same time in my driveway. It doesn't even need to go into the street. That is not a problem.
Okay, let's go through a limited number of questions on the material that Ms. Schaefer has provided, because sometimes a lot of this evidence can be duplicative or you know, just the same basic issue addressed a number of times. So
Okay.
please ask your questions of Ms. Schaefer.
So I have a question. Do you do yoga? Do you do fitness?
That's irrelevant. Let's move on.
Okay. I was just wondering. I do
Part of my
actually wanna
job,
know
part of my job is traffic cop. We're looking for questions
regarding the hearing.
that relate to the relief that you're requesting and the contentions that are being made by the adverse party.
Okay.
So you need to focus on the use of the property and issues that relate to the zoning question in front of us.
Okay.
So the
Well,
fact that
as
she
much-
doesn't do yoga is entirely irrelevant.
Okay.
Let's proceed.
Okay. So as much as I can remember of the many things that she mentioned, the door is off of my enclosed deck. I use that when I go out and I grill.
Please speak into the microphone so Norma
I
can get
use
all
that when I
this.
go out when I grill. I walk in and out of there to do when I cut my grass. That's just a door that's in an annex way next to my laundry room. It's a part of my house. It is not a part of the yoga studio. By the way, my size of my home is the same size as my neighbor, Marson, and I did find out that the actual space for the studio is within the requirements. I can give you those numbers afterwards, but I have the numbers of the size. I didn't know. I'd never measured it myself, but I do know now that it's within the requirements. So my question's for you about the Groupon, okay? You noted a Groupon, or I'll make a statement. Of course, you know, I tried to see if I could get people to come. That didn't work because there's many other gyms, there's many other studios. You know, this is back behind my house. I could show you my Groupon sales. I have had none. They were on there, but I didn't sell any. And I can actually prove that too if you require me to do that. If you could just put your papers down, if I could look through them one at a time just quickly to go through this. Some of this picture here was a picture I took, just a beautiful picture of the studio. No students, just the studio with mats. Okay? This on Zillow, this is my Mustang, which I love dearly, but that's a very old car that I sold to build my first studio. I sold that car for $17,000 and built my first studio in Newtown Square. This is my old Explorer. These pictures are ancient. They aren't my cars.
Ma'am, the issue is whether they're reflective of the current conditions on the property.
This is not my, no, this is,
Whether you still own the vehicle.
well, this isn't accurate because this isn't the cars that are parked in front of my house.
This was to show the size of the family room and the multiple listings.
One of you needs to speak into the mic, the other needs to speak into
I'd like to have these pictures.
That was presented to show the size of the room, and
Well,
that
I
was
actually do
consistent on the multiple listing services. I just pulled one.
But again, that's, you know, real estate information off of Zillow. I have the measurement of the room. I have the measurement of my home. It meets the requirements. So it's smaller. It's within the required amount. I can give you those numbers. Picture with mats, you know, everyone hoping that you'll get this amount of people, but I didn't. Picture the room, no people. This is ancient. I don't know whose cars these are.
This was a picture I took most recently.
Okay, so this could be my neighbor who has a new baby.
It was just to show.
Oh, that is my neighbor. That's not my house. That's Veronica Bay. That's in front of her house.
If I could interject, that was just to show the street and what Devonwood looks like.
Yeah, is parking permitted on one side of the street as opposed to the other? Can you park on both sides?
Both sides.
I need to go through these. I can't do them without looking at them.
Well, okay, I'll give them to you.
Ms. Schaefer, you really should provide the applicant with a set of your materials.
I do have a set, I just neglected to give it to her. But here, go ahead.
This one was me trying to market because I lost my studio in COVID.
Ma'am, we understand, we're looking to identify issues that are relevant to the request for relief from the requirements of the zoning code. We understand that that's a marketing piece, that there are other marketing pieces, but it's not particularly relevant to the fact that that your prior business had to relocate to this property. But
I understand what you're saying. I attempted to have people come, but it didn't happen. So basically, a lot of this is family and friends. It's a very small group of people. A couple of my neighbors. It's not my income. I became a public adjuster during COVID. I'm also in roof sales. This is not my income. I would be out of there in a heartbeat. I couldn't afford. This is just really mostly pleasure. It's a very small side gig, is all it is.
thank you. Ms. Schaefer, do you have anything else that the board should
The only
think
thing
about?
I was going to add was that the information I took from the website, I did notice the website was updated routinely with the schedule. I had no way of knowing that, I should say that Ms. Rainey had plenty of time to prepare for this presentation. If the information wasn't relevant, it should have been removed
I didn't
from the
have the money
website.
to do that, as I had said. Thank you, though.
Okay, I think we've heard from both sides. Thank you. Thank you, Ms. Schaefer. Thank you, Ms. Rainey. We've had public comment, right? Yes, we have. Okay, so both the applicant and the contestant exhibits will be entered into the record. At this point, I would entertain a motion from the board.
I would move that the application be denied.
Is there a second? Second. Board discussion?
I'll go first. I'll keep it brief. As much as I empathize with the applicant and hear what's going on, I just think that there's too many issues, there's too many elements to this application that don't fit within the confines of the code, and especially these specific sections. They are very specific, and to the extent that you know the size of the room is in question and the parking is inadequate. There's just too many elements here that I just don't think I can support the application.
I have to echo those sentiments. One of the reasons why we have to look at this so closely and so carefully is that the proposal is to have a commercial operation in a residential area. Now, at first, it may not bother anybody, but once it starts to bother people, then it's incumbent upon the township to do something about it. To what extent do we have to have our people monitoring and policing this? I think the applicant has arrived, and believe me, I'm not trying to criticize just for the sake of criticizing. But the applicant, I don't believe, has come fully prepared to answer all of the questions and satisfy, most importantly, satisfy the rather strict requirements to have a home business, especially a home business that requires other people from in the neighborhood or outside the neighborhood or from anywhere to come into what is a residential neighborhood and take advantage of using that property, a residential property, in a commercial atmosphere. And that's why we look at these things so closely. Now, with all due respect to the applicant, she did not come here prepared to explain just and satisfy the amount of space that's going to be taken up. We were basically being told, trust me, I'll take care of it. Can't operate that way. There's one thing is about the plantings. We didn't even talk about that, but it's very specifically stated in the code that there has to be an evergreen buffer planting strip. Such planting should be of the proper size to provide an effective screen at the time of installation. So you just can't put in tiny little trees. You got to put in a screen at the time of installation and subject to township approval. Now, the applicant didn't even speak about that, but yet that's another variance that has kind of crept into the process, not to mention the number of people who are going to be here or are going to be students. I mean, my sense is that the applicant is used to running a larger operation. If 10 people show up, 10 people will be accommodated. And the photograph shows that there's at least 10 mats on the ground. This is, I presume, her yoga studio that she's already set up in her house. So there's an awful lot here that I think militates and tells us that it would not be appropriate to grant this.
Yeah, I mean, I'm going to echo what I'm hearing on the board. I mean, initially walking in here and reading the materials, I thought this was a special exception. And then almost immediately in testimony, I'm hearing a variance, which are two very different ways we have to approach it, levels of evidence that we have to hear. It's more specifically a hardship, which I'm certainly not hearing that at all here. So, you know, again, I can't ignore, you know, that the requirements aren't met for the special exception in the code, let alone to rise it above a level of to a variance. So I think it's rather straightforward.
Okay, there being no other board discussion, I will call a vote. Mr. Weitzman?
I vote in favor of the motion.
And again, the motion is to deny relief. Mr. Lord?
I vote in favor of the motion to deny relief.
Mr. DeLizio?
Aye.
And I am also in favor, so that is 4-0. The relief is denied. Thank you. Okay, our final case this evening is appeal number 3104, the applicant Christopher and Tara Steinhauer, property located at 117 East Laurier Place and zoned R1 residential. Pursuant to the Township Code, Section 280-139A, and Township Code, Section 280-7E, applicants seek a determination that the property was approved as a density modification development and is therefore subject to the density modification provisions for the R1 residence district. In the alternative, the applicant requests a variance from Section 280-15F to allow up to 27% of impervious coverage on the lot. Mr. Brosman, good evening.
Good evening, members of the board. Good to see some of you in person.
Good to see you in person.
I don't know if Mr. Nagel...
I know where that was directed.
I don't know if Mr. Nagel is with us on Zoom or not. But if he is, I will say hello to him as well. Shall I proceed?
I'm sorry. Yes, the preliminary is out of the way. Yes, please proceed.
I want to introduce my client, Chris Steinhauer, as well. He's here, and I'll be asking him to be sworn in at the appropriate time. I'm representing Chris Steinhauer. He's the owner of the subject property at 117 Laurier Place. And you'll see in my exhibits that this is part of a development known as Laurier, which is a really nice development that was done in the late 1990s as a density modification development. I have an exhibit package that Ian has helped me put up on the screen, and I also have hard copies that I could hand out if the board would like to have paper copies as well.
There are additional to or supplemental to what you provided in the application?
Yes. A lot of them are repetitive, but I've given them new labels.
Certainly, our solicitor and Mr. DeLizio will need copies for the file. And I guess the rest of us will follow along on the screen.
Good to see you. And if others would like hard copies, I have some extras as well. So I'll get into it, but to put it in a nutshell, we're technically here on an appeal of a determination by Kevin Kachansky, the zoning officer. But to put it in a nutshell, what we're seeking is, as I said, and I'll go through the exhibits, this Laurier development was approved by the township as a density modification development. There's a whole plan of that. We have copies of the recorded plans. Mr. Steinhauer's property was Lot 5 on that plan, and we're basically just here seeking confirmation through this appeal that those density modification provisions that created the lot continue to apply. So we're just seeking confirmation of really what always was and we believe continues to be. But having said that, to run through some of the exhibits, Exhibit A1 is just a copy of my application, so I'm not going to go back through that. I wanted to note for the record that after I filed the application, I had used the deed that I found in the public records, which reflected the ownership of the property as Christopher and Tara Steinhauer, and I had attached that deed to the application. The Steinhauers were divorced, and a deed came back from recording that I now have in my exhibit package at A2 that Chris will verify. He is now the sole owner of the property. So I have that deed as Exhibit A2, and I would like to note for the record that the applicant should just be solely Christopher Steinhauer, who's here tonight.
So noted.
And I'm going to try to scroll down. This is just the original application. These were that was the original deed I spoke of. I have a larger copies of these plans that I'll be going through. These were the photos that are required to submit an application. Photos of neighboring properties that were required to submit the application. And I'll be talking about some of these documents. Here's A2, the deed that I mentioned that you can see Chris and Tara transferred the property just into Christopher Steinhauer. That's at Exhibit A2. So just procedurally, Kevin was kind enough to give me an email at A3A, an email exchange he had with Chris, and Chris will go into this in his testimony, but Kevin was kind enough to come out to the property to go over what Chris wanted to do, and there was an email exchange between Chris and Kevin where Kevin said that he didn't feel he could apply the density modification provisions. And then I also had a conversation with Kevin that is at A3B, and it's confirmed in the emails. I actually asked Kevin to reconsider, and he confirmed that we should come here to the zoning hearing board. So we have those determinations that we're technically appealing. Next in my package is A4. This is the current section in the zoning board or the zoning ordinance for density modification, and this is just a copy of the provisions. You'll note that at 280-90, they talk about the purposes of density modification, and it says in 290B, the means of accomplishing the objective shall be made only on the basis of subdivision or land development plans approved by the Board of Commissioners. And as you'll see in my exhibits, that's what happened here. The DeMoss family, who owned the tract, submitted an application, a land development plan, to the township to have density modification in the R1 district where the property is located, and that plan was approved by the township. And I'll be coming back to some of these provisions in density modification, you'll see that in 28094, it talks about area and height regulations, and it says in 294A that the building area coverage and the impervious coverage in density modification is 5% more than in the underlying district. And that'll be tied into another exhibit that we have when I get to it. So basically the gist of a density modification development is that in certain zoning districts, R1, where the property is, the township has an alternate way to develop a property. Instead of doing a conventional subdivision that wouldn't have open space, that follows all of the requirements of the zoning ordinance, the township provides this option, density modification, and it basically encourages the developer to provide open space and allows the lots to become a little smaller. Since the lots are a little smaller, the percentages of impervious and building coverage go up in recognition that it's done on a percentage of a lot basis. So this property, the Laurier tract, had over 48 acres. And in the density modification, if you have a 20-acre tract in R1, it qualifies for density modification. That's confirmed here in 28092 A1. The plans we have show that Laurier had 48.9 acres gross, 46 acres net, so it clearly did qualify for density modification. There's a requirement to have 30% open space, I'm sorry, there's a requirement for 15% open space, and the Laurier plan actually had more than that. Moving on through the exhibits. This, just for the record, at A5 is a current survey of the subject property. It shows the property on the corner of Laurier Place and East Laurier Place, and it shows the size of the property. It is less than the 1 acre that would normally be required in the R1 district. A6 is just the zoning map. I have a larger copy. The issue, I think, that gave Kevin pause is that the zoning map shows the property R1, which it is R1. That zoning stays with the property, but it did not note on here that it got density modification. Some of the other tracts in the township that went through density modification are noted that way. I'm submitting to the board that that's not a requirement that it be noted on the zoning map, but I don't want to speak for Kevin, but I think that may be what was giving him pause, which I understand. And then at A7, I think is really the key exhibits. And I have a larger copy, since these are sideways. Maybe we could do this both. If Ian is able to. So this is a full-size copy.
George, is this A7? I got it.
Yes,
Okay,
yes.
got it.
I've labeled them A7, A, B, and C. We just took some sheets, and Chris will testify. He actually got these from the county records. So this is the cover page. You can see that it's been signed by Radnor Township. It's been reviewed by the Delaware County Planning Commission, and it's recorded in the county. And you can see here that you have the Laurier subdivision. You have Bryn Mawr Avenue here. You have the bounding road down here, Laurier Place, East Laurier. Chris's lot is lot 5. You can see the open space. You can see that it's a cluster development like you would see with density modification, large areas of open space. And then going to A7B, this is another sheet of that recorded plan. The key thing here, maybe if Ian could even zoom in, it shows that it's zoning district R1, which is correct, but it says proposed site to be developed under density modification. It gives all the tract area data that I was referring to. It has all the calculations, how the Laurier tract met all of the requirements. for density modification. So it's clearly noted on this plan that it was a density modification plan. And as I noted, signed by the township and recorded. And then this is another sheet of the plan, and it's just more detail. Again, the lot in question is Lot 5, but you can see the whole density modification scheme here, the smaller lots, the clustering, and the open space. So I feel that it's very clear that this was approved, its density modification, and the whole layout, the whole scheme of the property with the required open space is reliant upon that. And I think confirming that is the right thing to do. I think it could even be alarming to some to say, well, now it's not density modification. What would that even mean with regard to open space and things like that? I also put in the exhibits, just so you can see, these are those plans. We just went over the larger copies. A8 is just some of the R1 requirements. What I wanted to point out here, 28015, normally there is a lot area of 1 acre. Chris's lot was approved at 0.69 acres, so it wouldn't have even been able to have come into existence if it hadn't been density modification. And impervious coverage, you'll see, is normally 22%.
I'd like to ask a question at this
Sure.
point, if you don't mind. I'm trying to get my mind around the fact that this lot number 5 that we're about here today was part of the Laurier-DeMoss tract. Is that correct?
Yes,
As lot number 5.
correct.
Okay. Somewhere in the township records, based upon what I've read and what you said, the lot is shown on a township map or a township zoning map in a different location, or doesn't have the designation that lots 2, 3, 4, and other lots that are on this plan have? That's what I'm trying to understand.
Yeah, I don't know
I'm trying to understand
if-
what gave Kevin pause here.
I think and I don't want to speak for Kevin, but I think I'm saying it accurate. What gave Kevin pause is that the zoning map, and I'll put up a bigger copy. This is the zoning map that I got off the township website. If we could zoom in here, please, Ian. I highlighted in yellow, or I highlighted around the Laurier track with the red dashed lines.
George, you may want to shift that map.
Okay, thank you for that.
Keep shifting.
So, keep shifting. So I took with my red marker and I highlighted the bounds of the Laurier plan that I just went over. Chris's lot, I'm going to put an X on it, is there. And you can see the yellow is R1. It is R1 zoning, but it's R1 subject to density modification. Some properties in the township, many, including right across the road, the map noted R1/DM, which I think stands for density modification. I don't know why the township didn't update the map, but my position is, A, it technically didn't need to be updated. It doesn't say in the density modification it has to be noted on the map. The R1 zoning does still apply. And even if it did have to be noted on the map, it's basically a clerical omission. And the recorded plan would be controlling, and that's what people bought into and relied on. So that's the only discrepancy I'm aware of, Mr. Lord, with this. Then the other thing I wanted to mention is that in A9, this was interesting, and Chris will talk about this. A prior landowner, the Carsons with a K, had apparently applied to the township for a grading permit in the year 2000, and apparently they applied for more than 27% impervious, which is, as I said, In density modification in R1, you can get 27, 22 plus 5. They applied for over 30%, but the reason I have this letter in here, it's signed by Duncan Hubley, who was the then township engineer. He says, he denies the permit, but he says in the middle paragraph, the plan does not comply with section 28094A of the code, which sets a limit on impervious surface of 27%. 28094A of the code is that density modification provision that I showed you in my earlier exhibit. So the township was clearly applying the density modification to the very property in question.
Are you suggesting that Mr. Hubley, at the time that that letter was written, was the zoning officer for the township?
No, he wasn't, but he was the engineer, and he was making a decision on a grading permit application, which would be under his jurisdiction, and he can't issue the grading permit if it violated a zoning. So he wasn't the zoning officer, but I submit that that is probative evidence that the township was recognizing, in addition to the recorded plan, that the township was recognizing that this is density modification in the R1 district.
Thanks.
I had a couple other exhibits I didn't mark that I can include in the record. I found the original letter that the applicant made the application for, and it says he was applying for density modification. And
This was in 2000, George?
no, and I'll mark this as an extra exhibit. In February 9, 1996, Lawrence Flick IV, who is a well-known real estate person in the area who used to help subdivide a lot of these old beautiful estates, he wrote a letter to the zoning officer, then Mike Flagg, F-L-E-I-G, applying for this subdivision land development plan. And he starts at the letter, and I'll give you a copy. This letter shall serve as formal application for density modification under Article 19 of the zoning ordinance, Chapter 280. And then we also found an application for Act 247 review that was related to that application. That's the application that gets sent to the County Planning Commission. That application says that it's also a 30 single-family residential lot subdivision created under density modification provisions of the ordinance. And then it's countersigned by Duncan Hubley, who would be the normal person to send that into the county. I guess I'll make the 96 letter Exhibit A. A10 in that county referral form, I'll make A11 if that's okay.
Without objection.
I think that's all I have. I wanted to have Chris sworn in and confirm some of these exhibits and tell you his story why we got here tonight.
I do. Christopher Steinhauer, S-T-E-I-N-H-A-U-E-R.
Chris, you're the owner at 117 Laurier Place?
Yes.
And that Exhibit A2, is that the deed that shows you now own the property in your own name?
That is correct.
And A5, that was a copy of the survey plan for your property?
Correct.
Did you hear my remarks about the history of the situation?
Yes.
And I had introduced an email exchange between you and Kevin Kachansky. Can you verify that was an email exchange you had?
Yes, I did.
And were you the one that actually got these plans for me from the county records?
Yes, we did.
And can you just very briefly tell, when you bought the property, what you were hoping to do and what brings you here tonight?
First of all, thanks for having me, and thank you for your time. In 2015, we moved to Bryn Mawr from New Jersey. I have a 7-year-old and a 10-year-old daughter. We bought the house. It was a neighborhood we loved, and one of the things that was very important to us was eventually putting in a pool or a backyard that we can enjoy with the girls. We when we purchased the home, we were given all of the site plans that the original homeowners had. That was something we discussed with the realtors as well, in that we wanted to have a home and the ability to put in a pool. We were also even shown that we were allotted 27% because of the density modification through this letter that I had shared with Mr. Brosman. And about 2 years ago, I started the process of looking into getting a pool. We had some drawings done. I changed jobs or employers, so I put that on hold. And then more recently, several months ago, we started to revisit the project, and I reached out to Chris Yawn, an engineer. We had some site plan work done, and after speaking with a few neighbors, they said, you know, this development is supposed to be density modification. They had purchased their homes believing the same was true, and then we kind of bumped into, well, at some point, DM either fell off the map or never made its way onto the map. And so we put the project on pause, hoping to get the density modification that we need to do the project, because without it, our oversized homes on undersized lots, it's impossible. And, you know, it's our dream to have a pool in the yard, and I would hate that to be denied as a result of a technicality that I honestly believe we should have, and is, as George mentioned, potentially a clerical omission or something that was never updated properly. In speaking with several other neighbors, all of them were saying, you know, thank you for doing this and being the one to actually present this to the hearing board, zone hearing board. Also, we believe the home values in the neighborhood will benefit from being considered DM, because one of the things that, you know, a lot of potential home buyers want in our type of development is the potential at least to put in a pool. Do you have any questions for me on the project? Or we don't have anything specific in terms of what we're going to do now, but in talking with the engineers and, you know, pool design companies, our deck, et cetera, everyone had told me there's no reason to spend tens of thousands of dollars designing something that you're not aware if you can even put it in, based on the uncertainty as to density modification versus not being DM.
Yeah, and any action that we might take this evening is limited strictly to the question that's in front of us, the request for the determination, as opposed to the question of whether any future project is going to comply with the requirements of the code. So that's a separate issue.
If approved, we plan on abiding by all of the rules and regulations as they apply to DM and the 27% impervious.
You know, I acknowledge your comment. We agree with that. I think that's all we have. I would ask my exhibits to be entered if they're
Without objection. Any other questions from members of the board?
I'm still trying to understand that, George, is it your understanding that I'm looking at this exhibit, which is A7?
Yes.
And I can make out, looks like lot 1, 2, 3, 4, and then 5, which is your client's property, correct?
Yes, lot 5 is my client's property.
Okay. Now, maybe you didn't focus very much on lots 1, 2, and 3 on this plan, but are lots 1, 2, 3, and 4, is there any dispute as to whether or not those lots are within the density modification area?
I mean, I'm not here for those lots, but
No,
I
I
believe
understand that.
I believe every lot on this plan is density modification. The tract is still zoned R1, but it's subject to density modification. So that open space on there has to stay. Those lots all exist, R1 with density modification. So every lot in here is subject to the same, we believe.
You good, John?
I'm done, thank you.
Okay. All right. The exhibits are moved into the record without objection.
Thank you.
At this point, I would make a motion. Oh, I'm sorry. Looking out across the public. We've been on Zoom. I'm out of practice, okay? Would any member of the public like to speak on this application? Okay, seeing none, thank you, Brad. You got to keep me honest. It's, there being no public comment, I would move that the applicant, well, excuse me, I would move that the board make the determination that the property should be treated as an R1 lot subject to density modification.
Second.
Any discussion? Yeah, and I just want to note for the record, I completely understand, Kevin, your determination, because you have the map that's in front of you. And there's a separate issue as to what we might do to get that map updated, but I think it's clear based on the applicant's evidence offered this evening that the map just didn't get updated after the DM development was approved. So no other discussion. I'll call the vote. Mr. Weitzman?
Aye.
Mr. Lord?
Aye.
Mr. Delizia? I'm also in favor, so it's 4-0. The determination is made that the property should be treated as R1 DM. There being no other business before the board, I would remind everyone that we do not meet in August, and we will be back, you know, I wrote this down. Third Thursday of September, whatever date that happens to be, right? Oh yeah, there it is, on the 16th of September. Otherwise, have a wonderful remainder of the summer, and we'll see you in September. Thank you very much. We don't have gambles on Zoom.